Good afternoon, everybody. You have Michael Smikun from Callagy Law. It is now 12 o'clock on the dot, and we're about to get started with our webinar talking about the brand new out-of-network legislation. With me, sitting to my left, is no other than the wonderful Sean Callagy.
I'm definitely not wonderful. So hey, folks. So listen, thanks for being on. Our desire, there's been a lot of things going on, a lot of talk, and we went to see something tonight, and have been at many lawyer discussions. And contrary to what people may hear about us, because we do sell and market hard, the content is the key and the information we're going to exchange today. There is so much fundamental misunderstanding about what is happening. It's utterly outrageous. And there's things that unquestionably need to be done, and this is not hype, it's reality, that people have to implement. And there is a war going on with the insurance companies trying to end out of network. And the only mechanisms for you to fight and battle against it are here. And we're going to talk about them. But the real issue is going to be how much you accept and implement within your practices. And with that said, I'm going to turn it back to Michael for the content. The information is essential. There's not one thing we're going to tell you that you must do that is something you can get away with not doing. Otherwise, you're going to get the numbers jammed down your throat, and you expose your practice to enormous liability that people are not understanding. So, and on our end, please stop going in and out the door. Leave the door closed. Thank you. Go ahead, Mike.
So Sean is exactly right. A lot of people talk about the positives and the negatives of this legislation. The truth of the matter is that this legislation definitely hurts out-of-network providers. It creates a whole lot of obstacles, a whole lot of hurdles for the medical providers, the out-of-network medical providers to overcome. And that's especially true in the context of healthcare facilities. And so, we use very strong language here, evolve or perish. And the truth of it is that if you're not going to follow the disclosure requirements and you're not going to follow all of the other disclosures, all of the other rules and legislation that's created by this brand new act, you're going to get yourself into a boatload of trouble. And that's especially true in terms of the penalties and things of that nature that come at the tail end of the act. And so, without further ado, I'm going to switch over to some of the substance that we have going on here.
Real quickly, let me introduce Michael also. It's really interesting. So I've heard some people talking recently, and they go through years in the business. I don't believe that years in the business mean anything. But Michael and I have been working together for 9 years, and here's what means something. He co-counseled 2 top 100 national jury verdicts with me, which make us only one of 2 law firms in the country to do it. We've collected $50 million in 2017 alone from insurance carriers. This is all about understanding the psychology of how to produce results. The content and information means nothing without the implementation and enrollment of staffs and teams and physicians, billers, office managers, and people driving it. That's what we're here to talk about. So when it comes to this information, some of this is going to be new and challenging. My desire right now is to pattern disrupt and interrupt everything you're normally doing. It has to shift. And there's going to be things that are a little bit difficult. And in fact, that may sound quite difficult for you to do, but they're not that difficult. It's easy to shift. It's easy to implement, and people can still win this battle and this war, even though the legislature has failed in what it has done here. Right? But the acceptance of what is critical. Fighting against it, complaining about it, whining is not going to help. Creating changes in the legislature will help. That's not happening anytime soon. Not happening anytime soon. That battle has to continue. But the mission is to educate and implement. That is the issue. And to make sure you're prepared to litigate, because you're going to have to. And you have to litigate regularly. And I'm not saying that to generate business. If it's not us, use somebody else. But sure as hell make sure that people know what they're doing. They're not, and on a comprehensive level for your practice, both dealing with not only the many distinctions that Michael's going to talk about in terms of the different types of commercial insurance issues that are going to arise. Got Mike.
Perfect. So this act is now law. It was signed by Governor Murphy at the beginning of this month on June 1st. And so based on the terms of the act, it's going into effect September 1st, 2018. So now is the time to be getting yourself into a position to follow the guidance of the act. So it is now law, folks, right? This is not something that may happen. it has already happened. And so let's be ready to go, make sure that your practices are in shape, that you understand the disclosure requirements, that you understand the prohibitions that are set forth and how this is all supposed to function, because as of September 1st, this thing is live. So one of there's about 5 key features that we're going to go over in terms of this act. There's a lot of nuance to it. It's a 20-page act. It is very dense. It provides a whole lot of information, and it's not provided in a very coherent fashion. In fact, it's kind of difficult to understand even for attorneys. So the act is going to impose new requirements on providers. If you fail to comply with them, there are very strict penalties, and in addition to the penalties in the act, there's also going to be potential referrals to the Office of Insurance Fraud Prosecutor. Right? A lot of you may be thinking, this act is devastating. How do I continue to operate as an out-of-network provider? Maybe I should just be going in-network. And as I talk about what's going to be happening here, I'm going to say that going in-network may not be the right thing for your practice. It may not be something that's even available to you, because as you have similar medical providers that are out-of-network saying, I'm going to go in-network, you're going to have the horizons of the world able to pick and choose who they want to enter in and reject the others by saying, hey, the market is saturated in your area.
Yeah, and now listen, and this is to say also, it would be entirely self-serving for us to tell you that unquestionably you must remain out of network. I think that for the future of our country, out of network is important. I believe in capitalism. We believe in doctors controlling care. We believe in patients having choices. And I sure as heck don't want to live in a space where all physicians are in network. And at the same time, it's an incredibly personal decision about whether somebody goes in or out for your practice and your situation. If you're in, then really there's not a lot of work for us to do. So our self-interest, selfishly, is that everybody stays out of network. And we want you to do that. But quite frankly, if it has to be consideration that people make on an individualized basis. What cannot happen, what utterly cannot happen, is that people make the decision to stay out of network and say, we're going to deal with fee forgiveness issues and those things simply by ignoring them. That would be insane. And we'll tell you more stories about that later. But yeah, we believe that there's unquestionably still the better path for most people, if they're going to be willing to do the work and to navigate this process, is, in fact, to stay out of network generally. That's not legal advice. We'd have to talk individually to your practice, but that is our belief. And we believe you're fighting the good fight. We believe that's what's better for New Jersey, America, our medical system, to not let the insurance carriers win, put everybody in and control all of it. That is a place that nobody should be in this country. We believe that. If we're advising people individually, everybody has their own family and self-interest to consider. And so, it can't be ignored what's going on.
So the next question that many of you have asked, and we've heard questions from a lot of our providers, is who does this act actually cover? Is it just emergency room services or urgent services? And the answer is no. It basically covers all out-of-network providers. And so while some of the most stringent requirements are now placed on emergency services and urgent services, and what the act refers to as inadvertent out-of-network services, out-of-network providers that are providing elective procedures out of your offices and things of that nature, you are impacted by this act as well. I can't be any more clear than that, because there's been a lot of misinformation going around saying that this is just affecting emergency room and urgent services. So the act specifically defines 2 categories of classes of provider, and that is the healthcare facility and the healthcare professional. Just generally speaking, the act explains that the healthcare facility really applies to hospitals and ambulatory surgery centers and other similar facilities. And then there's separate sections dealing with just healthcare professionals, and that's the individual doctors or the smaller entities, surgeons, neurologists, things of that nature, that are providing their services outside of the context of a healthcare facility. So you have both healthcare facilities and healthcare professionals that are impacted by this act. Another question that we're asked very frequently is, who will the act affect, right? Is it gonna be all my patients? No, the answer is it's gonna be probably less than half of your patients. This act does not impact self-funded policies or self-funded plans. There is a possibility that these plans are gonna be able to opt into some of the requirements of the act, but I highly doubt that is ever gonna happen. In fact, there's parts of the act which I think are going to be preempted by the ERISA statute. And so you're going to have people that are supposed to be included inside the act that are going to be able to avoid being a part of the act. And they're going to say, you know what, this law goes too far. It's preempted by ERISA.
Yeah. So and let me just say this, from a credibility perspective, I think sometimes people see us as a PIP arbitration law firm. That is certainly something that we very confidently believe objectively file twice as many than anybody in the state, but that is a fraction of who we are and what we do. We're involved heavily in high-end business and commercial litigation, practice defenses, and we've been involved in the commercial insurance battle. It's not a marketing call, it's a credibility moment, okay? We've been involved on the forefront of commercial insurance issues for years in the state of New Jersey, filing federal lawsuits under ERISA. We've been involved in multiple federal circuit court issues, including the Mirza decision, and a more recent decision that I won't steal Michael's thunder talking about it, as well as Ninth Circuit appeals, which we prevailed on. So we're involved in federal court litigation within the circuits and the legal nuances that are involved. So I just want, from a perspective of credibility, this isn't new to us, right? We've been litigating these issues, and there's been some really positive developments that have happened on the litigation side we're going to share with you that have very real, meaningful opportunities for your practice, as well as what's going on. So when you're hearing what we're saying, this isn't us jumping into, wow, people are scared and there's something going on. We have an opportunity to get a bunch of people on a webinar and sell what we're doing. This is meaningful information from people that are studying what's been going on. And we've been involved in commercial insurance litigation for years. And the nuances we're going to discuss come with that level of experience. So that might be.
So, probably the most important plans and policies that you guys are going to be dealing with on a regular basis are going to be your Medicare, Medicaid plans, which are not covered, PIP policies, workers' compensation policies, and like I said, self-funded ERISA plans, will not be impacted by this. So what you're really dealing with is, and I'll explain this a little further on, we're talking about fully funded or fully insured, whatever language people are using, health plans that are going to be impacted by this.
Can you just, because that's so confusing for people, can you just for a second explain the distinctions in a practical sense? When somebody walks into the office, you see this type of patient, it's probably fully funded or self-funded. Explain those distinctions.
Yeah, absolutely. So what we're actually dealing with is when we're talking about self-funded versus fully funded, the difference is as follows.
And say it one more time. This plan applies to which of those two?
The fully funded plans and self-funded plans that opt in, but the reality is, Sean, they're never going to opt in.
Absolutely. So just to be clear, so most self-funded plans initially, this act has no application.
That's exactly
just to be
right.
really clear for people.
Yes.
So self-funded, no application, fully funded, application. What's the difference between self-funded and fully funded? How do they sort of, on a gut level, know? Go ahead.
Sure. So when you're talking about a fully funded plan, what you're dealing with is your traditional insurance. So a friend of yours is unemployed and says, hey, I can't go through life and not have an insurance policy. I'm going to call up Horizon and say, hey, Horizon, I'm an individual. I need a policy to cover me in case of a catastrophic loss or I'm injured or something along those lines. Horizon goes, sounds good. We're going to underwrite your policy and we're going to issue you a policy of insurance, provide you with information about what benefits you're entitled to. And the hallmark of a fully funded plan is that the person who issues the policy or the plan is the one who's going to pay the benefits. And that's why it's referred to as a fully funded or fully insured plan. That's the traditional.
Right. Give some examples of what those policies are, who's carrying, what the carriers are.
Yeah, generally you're talking about your Horizons, your Cignas, your Aetnas, those fellas that are inside the market. They're the ones who are writing the policies of insurance. I know Aetna has recently changed some of their policies and they're not underwriting as many of these fully funded plans, but they're still in the market of doing this kind of work. By contrast, and this is the huge distinction, a self-funded plan is one in which there is an independent funding source. So one of the examples I like to use are union health funds, or let's just use Coca-Cola. So Coca-Cola wakes up and they go, hey, why am I buying 100,000 policies of insurance? Why don't I just take all this money that I'm paying for the policies of insurance, the premiums, I'm going to lump it all into a fund and I'm going to administer these funds and pay benefits myself. And so the Coca-Colas of the world basically say, hey, we're good at making soft drinks. We're really not that good at administering claims. But you know who is? Horizon. Horizon's pretty good at administering claims. So they contact Horizon and they go, hey, we got this fund, we got a bunch of money, we have a bunch of people who are looking for benefits. Will you do our claims processing for them? And Horizon goes, yeah, sure, of course we'll do that for you. Horizon's not on the hook. They just do the claims processing. They make determinations, and then they tell the funds, meaning Coca-Cola, pay this amount of money to this person. Those self-funded plans are governed under the ERISA statute, which does not fall into this act. So the self-funded plans are not going to fall into this act.
Teachers, police officers.
Yeah, the government employees all fall under, will apply here to this act because it's a government act. But yeah, it's a little bit of a nuance.
Yeah.
And so when we're talking about what patients will be affected, Sean hit the nail on the head. You have government employees, teachers, firefighters, things of that nature will fall under, the state health benefits plans. You have fully insured ERISA plans. I put an asterisk there because I think that these fully insured plans that are governed by ERISA are going to turn around and say, no, we're not. We're not governed by this act. We're governed by ERISA, and it's preempted. We're not going to be able to get into it. We have certain self-funded ERISA plans if they opt in, and then private insurance plans is generally what we're used to dealing with. So,
hey, Mike, can I just ask a quick question?
We have James Greenspan. James runs our PIP litigation team. He's on the advisory. Go, James, real quick.
Yeah, I've been managing PIP here at Callagy for 4 years. I've done a couple of thousand arbitrations. I'm on the Forthright Advisory Council. Forthright being one of the arbitration entities that will likely be vying for the arbitration process that we're going to get into in a little bit. I just had a quick question for Mike. You've used the word preemption a couple of times. For those people that aren't sort of versed with the legalese of it, can you explain that term?
Yeah, sure. So, and I apologize, I sometimes take for granted certain facts. So preemption is a legal theory, or it's a doctrine that basically says that if the federal government has stepped into the legislation process and have made laws policing certain activity, such as in this case it would be self-funded health plans, then the federal government would essentially take control of all of that law, and any law that's passed by any state that would otherwise interfere with that law is essentially ignored for the purposes of construing of the law.
Right. So the practical application is there could be litigation about the breadth, scope, and application of this act in certain respects with certain plans and people. Fair?
That's exactly right.
Okay, so all you need to know is there's some complexity on what this will apply to, and those are things that unfortunately, you're going to need legal counsel and assistance to help to figure out and assess as time moves along, and to realize that the carrier is going to take positions that you're going to have the ability to fight back against. I think that's the practical meaning when we start talking about words like preemption.
Yep, absolutely. And so, one of the questions we get very often is, how can I tell? The truth of it is that sometimes these insurance companies don't even know if they have a self-funded or a fully funded plan. And most of the times they don't even have a copy of the plan itself. They got to go out and they got to go get it. But there are several surefire ways to figure it out. And one of those is to actually request from, if a person's employed, to ask whether or not they have employer provided insurance. By and large, those folks are going to have self-funded health plans. Sometimes it'll be fully funded, but I would venture to guess it would be an overwhelming majority are going to have ERISA-based plans, especially if they're with large employers.
So if they have an ERISA-based plan that's self-funded, does this act apply or not?
No, it does not.
Okay, right. So,
and so in furtherance of that, you also want to know what you're going to get reimbursed, whether or not this act applies. And so in those contexts, you have to be educated enough to understand where the information is for you to understand the reimbursements that you would get under these self-funded plans, which are not governed by the act. And that is through a document called the Summary Plan Description, which is also called the SPD.
Yeah.
Chances
now, for those watching at home who are like, okay, I knew everything and I know all this information. This is such a hot area, the Summary Plan Description, because amongst our client base and the people we talk to, and we represent hundreds of practices, there is such a disparity in the gaining, gathering, the acquisition of the Summary Plan Description. We're going to talk about what it is and how to get it. And if you're not getting it, understand you're like, well, that's too difficult, it's too confusing. Understand that other practices just like yours are getting it. And one of our main initiatives over the course of the next months is to make practices become incredibly proficient at acquiring the Summary Plan Description. It is imperative to acquire this. Some practices do it flawlessly. And if you're not, then there needs to be some behavioral changes, knowledge and behavioral changes in the practice. It is entirely doable. Agree, Mike? Yes.
100%, yes. And it's about getting the right documents, making the requests to the right people,
So
and getting
let's
those
go.
materials. So the other way, actually, and this is not shared globally, it's not common knowledge, and you'd be surprised how many insurance attorneys don't even know how to figure this out. But sometimes the insurance card has that information. And so I don't know who provides your policy or plan of insurance, but if you pull up one of the insurance cards, what'll happen is on the back of the card, what is numbered as 12 on the slide, if you're seeing it, there will be information about who actually funds this card. In this instance, this card does not appear to be fully funded. It is possible that it is, but I did this anecdotally, and I flipped a couple of people's cards as I looked on it. And if in this case it's Horizon, if Horizon is funding this and it's a fully funded health plan, guess what? It literally says insured by Horizon. So you'll have an indication that this will be a Horizon fully funded plan. And then when you look at that card, this person is subject to the Act. And so your requirements have to follow, your actions have to follow the requirements of the Act. So, look at the card. Sometimes it has information, especially on the back of it in that bottom left-hand corner.
And of course, we're going to be telling you that if there's questions, you should proceed as if the Act applies.
Yeah, that's
right, out of your own caution. So we're going to get there. But in case you're like, oh my God, this is so overwhelming. Well, we're just explaining some of the parameters. But yes, if there's any confusion, you're going to have to act as if.
Yeah, the truth is setting up two processes and trying to maintain both of them, I think, is trouble. And so there should be one process in terms of dealing with all these issues to make sure that you are in compliance with the Act and avoid any kind of penalties, which we'll talk about shortly. So, for the purpose of this conversation, we could spend all day talking about this Act, and I'm a little bit of a law dork. I probably would spend all day talking about it.
I have been vehemently opposed to Michael being a law dork on this phone call and talking about the practical application of everything. And Michael's not a dork at all, but in fact he is at sometimes. But we're working through this to give you practical information. So let's keep moving, and let's start to move into the as much practical space as we can.
So we're just about to enter into it. So you have 5 key areas of the Act that you absolutely need to know. Number 1 is the increased disclosure requirements for healthcare providers. Number 2 is the out-of-network billing requirements. Number 3 is the arbitration process to resolve disputes. Number 4 is the prohibition on waiver of patients' cost-sharing obligations. And number 5 is penalties. So here we go, folks. So, what key definitions do you need to know? We talked a little bit about what a carrier is. The Act is very clear. We're talking about fully funded plans, some fully funded ERISA plans, some opting in ERISA plans. You have your state health benefits plan and certain private plans. What health benefit plans are we talking about that are going to be covered? All fully funded health plans and government plans. But the one thing or a couple of things that you need to know is Medicare, Medicaid, not included. Workers' comp and PIP, not included. So there's a whole list inside the Act that's provided, and we will definitely provide a copy of these slides. And in addition to that, we have an entire paper analyzing all these issues. If you guys are as interested as we are, and I think you should be, because of the impact it has, we will be providing a copy of that to you at the end of this webinar. So number 3, what is a covered person? Again, not every patient is covered. Right? In order to be covered, a person has to be subject to one of these health benefits plans, usually a government-based plan, a state government-based plan, or a fully funded health plan, an individual or small employer who goes out and buys policies of insurance instead of funding it themselves. So there's a lot of talk about inadvertent out-of-network services. This is the thing that probably gives me some trouble with regard to how the Act was written. And basically, if you're in an in-network facility like a hospital, virtually any service that's provided by an out-of-network provider suddenly becomes this inadvertent out-of-network service. It's so broad, it's almost impossible to exclude anything from it, but it's important to know for the purposes of providing out-of-network services in an in-network facility. So you have this wonderful language that's in there, and I say that a little tongue-in-cheek, about knowingly, voluntarily, and specifically selecting an out-of-network provider. None of those terms are defined inside of the Act. It is very, very confusing as to when a patient is knowingly, voluntarily.
And let me jump in real quickly. So what we're really talking about, folks, right? And we were at an event the other night where I think there was just a general solicitation done for business, and there was such an absence of content for what the real point of this is. The point of this is the carriers are going to use this as a weapon, no differently than in 1999 when the Auto Insurance Cost Reduction Act was passed in the state of New Jersey, and in conjunction with the Insurance Fraud Prevention Act. It became a weapon that was launched by carriers in the auto world and certain specific law firms to get, to me, what was a corrupt and biased judge, Judge Villanueva, and God rest his soul, but he was corrupt and biased, and I filed a motion to that effect in, I think it was 2001. It was outrageous, the things that were going on, and it became essentially a witch hunt. This act, if people are not intelligently approaching compliance, is going to be, it gives the carriers the ability to do the same thing that was done in, as we rolled from 1999 to 2000, 2001, which was this weaponized attack with this utilization as though they were a plaintiff's law firm, right? So, Michael, do you agree with what I'm saying or not?
Yeah, absolutely.
So essentially what we're doing is we're advising you on like interrupting your thought process to realize, not to scare you, to realize that you must change, right? That there needs to be changes along a certain number of lines to protect your practice and to collect your money. And it's very real. And that's what this act is all about. And anybody that gets up on a stage and tells people, well, there's really, it's not so bad. It is bad. It is bad, but it's not death. There's a difference between not bad, right, and death. It is not death, but it is extremely challenging. And there's things that must happen. Otherwise, you're going to put a target, on your forehead. So go ahead.
Yeah, absolutely. And so, this is a tough definition to get past, but it's going to be construed as broadly as humanly possible to make sure that people, are either knowingly, voluntarily, and specifically selecting an out-of-network provider, or they're not. And so, you have issues with your disclosures. I'm now talking on behalf of the carriers, but it will be used as a sword. So be mindful of that, in terms of the future and what that brings. So now that we got the definitions and the background out of the way, let's get to the meat of the disclosure requirements. So again, these disclosure requirements apply both to out-of-network emergency or urgent services, inadvertent services, but also elective services. And so there's been a lot of confusion. Again, I won't belabor that
confusion.
point.
Say misinformation.
Yeah, misinformation.
Call it like we're not the people that dance around issues. There's been utterly ridiculous misinformation provided by law firms in this state about what this is.
Yeah.
So I'll say it. Good.
So a lot of, as Sean said, misinformation that this does not apply to elective procedures. It absolutely does. So, what we're doing here is we're going to provide you some commentary with regard to each of the disclosure requirements. But basically what we're dealing with now is the healthcare facility disclosure. So this is your hospitals, ambulatory surgical centers, and similar facilities. And basically, much of this has to do with the disclosure requirements are for your non-emergency or elective procedures for the hospitals. Not too much is dealt with on the emergency side in terms of disclosures. There's not much you can do. But basically, these disclosures apply to all elective and non-emergency services. The first of these disclosures is pretty self-explanatory. You have to when a person comes in for an elective procedure, you have to tell them, are you in network or out of network, right? That just has to be done. In the past, I think there's now a policing, right? This is clear cut. There is a policing of the use of the term accepting, right? Oh, we accept your insurance. The act is now making you go even further and not say, hey, we accept your insurance, which could go for in network or out of network. But no, we're either in network or out of network. And that's the number one disclosure right there with a bullet. To take out the possibility of using the term accept, right? So that's one of the requirements for the facilities. In addition to that, the rest of the requirements are all basically broken up into various sections, which basically says, facilities must advise that the covered person to check whether or not the physician arranging the facility services is in network or out of network. So your doc who's setting up the appointment, right? And saying, hey, we're going to do this surgery inside of Meadowlands Hospital, or we're going to do it in any variety of different hospitals in the area. You need to be able to figure out, the facility needs to be able to communicate whether or not your doctor's in or out of network. And in addition to that, if there's going to be other ancillary services like anesthesia, radiology, lab work, or anything along those lines, they need to provide you with that information as well. And that they use the term reasonably anticipated. Folks, that is legal talk for you better do a good job about this or we're going to come after you. So if you knew or should have known or reasonably should have known, you have to provide this.
So here, I'll put this into my language. Okay. So here's where we are. The ability and skill to sell. And we use that word interchangeably with educate, communicate, teach, sell, lead. They all mean the same thing. It's taking an idea and a concept, communicating with another person, having them understand it with complete integrity and authenticity, and agree to move forward with it. The people having these conversations, which include doctors, you are now a salesperson. To be in the out-of-network world from this day forward, you are going to need to take your communication game to another level. And by the way, in case you're like, okay, here they come in to sell us something, I'm not selling you anything. We give that away for free at a variety of different trainings and stuff we give away for free online. Here's my sales pitch. We give away such incredible content information everywhere that shows how smart we are, effective we are helping you, that you just eventually want to become our client. That's how we sell you. We're not selling a program. We're not, asking for money. We want to give you content, give you information, give you content, give you information till you realize that we're the only resource and source you should be talking to. That is our entire strategy. So there you go. That's our underlying devious and diabolical motive to give you so much great stuff that you want to work with us. That's it. Okay. So done. Learn to sell. Learn to sell. Learn to communicate with authenticity and integrity, because it's the only way to sell. We'll give you some ideas and recommendations about that at the end. Books you can go buy that we don't make any money for. Go read Tony Robbins' Awaken the Giant Within. Read The Greatest Salesman in the World. Read Napoleon Hill, How to Win Friends. Think and Grow Rich. Dale Carnegie, How to Win Friends and Influence People. These books are incredibly important. We're in a different world now. We're salespeople as doctors, lawyers, accountants, and professionals. That is a fact and a reality. And this act is going to require the ability to communicate with people with skill, not manipulate people, not lie or deceive people. But if you think you're going to be able to simply dance around this, manipulate, or hide facts, you're going to get in trouble. And number two, if you're going to think you should be able to tell people, well, I'm on the only game in town, which I was at an event recently and heard somebody stand up and go, well, I'm on the night, there's nobody else here. I'm the only game in town. You think that's going to work? No, it is not. And it's going to get you into big problems. But what will work is empathetically building incredible relationships with people to talk about your skill sets, who you are, why you are, very rapidly and effectively, and comply with these things. Because on the other side, if you go through a rote discussion of what these disclosure requirements are, nobody's going to treat with you. And they're going to run. And it's going to be a big problem, and the insurance carriers will have won. So your ability to communicate and influence is utterly important. We have great videos and on it for free on YouTube. Watch them. Practice Mastery Webinar 1, 2, and 3. Practice Mastery Webinar 1, 2, and 3. You go, oh, you're promoting. I'm not promoting anything. It's online for free. I'll never even know if you watched it. Right? We're trying to help and give you essential information about this. And if you don't want to do all that, then go and network. If you don't want to enhance your sales skills, if you don't want to enhance your rapport levels with people and handle these communication dynamics, and you're like, screw it, then go and network. I wouldn't do that if I were you. I wouldn't advise my family member to do that. But if you're not going to take the bull by the horns and grow and have an open and growth mindset, yes, then pack it in and go and network.
Perfect. So we covered, that first requirement in terms of the elective non-emergency services. The next part of this act talks about when you are an in-network facility, what kind of information you have to provide. And basically this all boils down to advising the patients that they have a financial responsibility only up to the in-network procedure rates and nothing in excess of the co-payment deductible and co-insurance. And that if they go out of network, they have to understand that they're going to end up paying more, and that they may be responsible for the excess charges if they use an out-of-network doctor or an out-of-network facility as opposed to an in-network facility or an in-network doctor. On top of that, it also talks about, hey, you should also, by the way, if someone tries to trick you and send you a bill for more than what you have to pay, you should report them. So that is a disclosure requirement now on the facility, that you have to tell the patients, the covered people under this act, that they should go and report, to the carrier, the medical doctor who's in violation of this act. So,
and for those of you that feel like nauseous right now, we're going to be giving you some practical things that we think can help in this conversation, so that people aren't just going to go running away screaming, right? And where there could be a level of alignment created between the patient and physician to make sure these bills get paid. That is going to mitigate some of this draconian insanity that's been passed in this act.
Yep.
Mike, just a question.
This is Tom LaGreca, who runs our Medical Revenue Recovery Division. Tom, please fire away.
Hi, everyone. Just by way of clarification, all of the requirements you're discussing now, are they elective surgeries?
That's exactly right. So it's the requirements that we're talking about right now is for elective procedures, non-emergency procedures. So, there's the EMTALA exists, they're required to stabilize you if you come into a hospital emergency room with gunshot wounds and things of that nature. They're not going to say, hey, I know I'm wheeling you into the OR for trauma, but I need you to go ahead and understand that you're going to get operated on by an out-of-network provider. The law is designed to deal with emergency services in terms of cost and things of that nature. This is purely for elective procedures. So EMTALA still applies. And
What's EMTALA? Explain what that means.
So that's the emergency. I forgot exactly what it stands for, but EMTALA basically is a requirement that if a person's in active labor or they sustain some kind of trauma and are now in critical or unstable condition, emergency rooms have a obligation as a matter of law to treat you and stabilize you, whether or not you have insurance.
So you don't have these, in those situations, you do not have these disclosure requirements.
That is absolutely correct, yes.
Okay. Just give them the practical for people.
Yep,
right?
100%.
So say it again, just really quickly, okay?
Yep.
Make sure people know.
So again, this does not apply to your emergency or urgent treatment. Again, a person
Life-threatening,
Yeah.
labor.
Person comes in with an active heart attack or a cardiac arrest, you're not making these disclosure requirements to them. So this is for emergency and this is for elective non-emergency services. So we provided some commentary in the slides. I want to be able to move through this because there's going to be some practical information. There's a lot to share, folks. So the slides will all be available. You can have all of our commentary on these acts to provide additional information to you. But not only are we dealing with, when you're in network, you also have to be able to identify when the covered person is, I guess in this situation wouldn't be a covered person, when their insurance is through a self-funded plan. Now, good luck with that, because you're going to have a lot of trouble identifying when a person has a self-funded plan to be able to provide them these disclosures, but yet the Act makes it a requirement that you provide certain information related to the extent or excess of bills that they may receive if they opt to go with an out-of-network provider. I don't know how the healthcare facilities are going to figure out a person's self-funded. The attorneys have trouble doing that on both sides of the fence, and it's not until you get a copy of the SPD is that immediately clear. So that's what the disclosure requirement is. It exists inside the Act. That's going to be trouble. I can foresee it already. So that's Section D of that section. And again, more commentary regarding how to deal with these disclosure requirements. Now we venture into when a healthcare facility is out of network and what's required in terms of the disclosures. And in this situation, the disclosures are different, right? Disclosures are different for in-network, disclosures are different for self-funded, disclosures are different for out-of-network. In this situation, the disclosures all wrap around the fact that, hey, you're being treated by an out-of-network facility. So you're going to get hit with a balanced bill. We want to make sure that you understand that. And you know what you should probably do? Contact your carrier and get a further consultation about where you should treat, because it shouldn't be in an in-network, in an out-of-network facility. So again, these disclosure requirements apply to out-of-network facilities. And again, we have some more commentary on this. We also have this section talking about public lists of facility standard charges and things of that nature. You have to follow federal guidelines for that. This one's trouble as well. There's going to be a lot of cost information and charges and information that has to be provided by healthcare facilities. So I would be very mindful of this. The Department of Health will specify what this is supposed to look like. It hasn't come down yet, but there is some federal guidelines to provide those disclosures so you're ready to go when this act becomes live. So in addition to the verbal and written disclosures that we just talked about, there's also disclosures that have to be on your facility's website. We broke these down. Probably the most onerous of all of this is all of the medical providers that are in or hospital-based physician groups within the facility. You got to provide as much contact information and information about their status as you have in your possession, and that includes the anesthesiologist, pathology, radiology. You're talking about all of the, I hate to refer to it because it's really not.
When you say, Mike, let me ask this. What do you think in terms of how? How do you have to provide this information? Where do you have to provide this information? We're saying provide it.
Yep. So, and I apologize if that was unclear, but it has to be posted to the facility's website. So this information, if you have a website, and most folks do, and you're a healthcare facility, it has to be posted to your website. So this information has to be readily accessible. There's no guidelines as to what it's supposed to
So
look
we're
like.
not talking about handing people
That's correct.
this booklet of insanity.
Yep.
Right?
If someone is looking for this information, they need to be able to pop onto your website, find out who's the doctor, their status, the mailing address, telephone numbers, contact information, things of that nature, including any anesthesiologists, radiologists, lab work, things of that nature. Okay.
And Mike, this is James, if I may jump in real quick. Going back to the very beginning, this is the law, and people have 90 days. It's in effect on September 1st. This is going to take a while. This is a big organizational project. They have to update their websites. They have to put together clear and concise lists that the consumers can access. So that's something that they need to get started on immediately and urgently, so that by the time the law comes into place in September, they're prepared.
And I've heard some people say, we're just not going to comply. I'm telling you, that is an option. That's not an option.
Yeah.
I mean, that's the end of your medical practice and career.
Yeah.
So you non-compliance and saying they're not going to fine me. And I had some crazy people I heard talking, saying that, well, it's going to be too many people to enforce. That is not going to happen. I promise you. And you're going to end up on the wrong side of a multi-million-dollar lawsuit brought by insurance companies and referrals all over the place for criminal prosecution. Not an option.
Yeah. And so
just keep going.
in furtherance of that, James saying, hey, we don't know how we're supposed to comply because we don't have an answer from the Commissioner of Health just yet. And I'll explain this in a second. We'll just wait for guidance. I think that's a horrendous mistake. I really do. I think I would come into compliance to the greatest extent possible. And when the Commissioner finally does lay down the design or content of what these disclosure forms are going to look like, you have to change them, right? Don't wait for this to happen. The rulemaking ability of the Commissioner of Health, and he has rulemaking capabilities here, should not govern the decision making. And I think it's going to be, like Sean said, it's going to be a bad day when you're not in compliance on September 1st. Because on top of that, there's penalties of $1,000 a day, up to $25,000, and referral to the Office of Insurance Fraud Prosecutor. So you don't.
And the ability to use this as the basis to argue insurance fraud.
Yeah.
Right. So a completely separate, fraud count brought by the carrier to use these guidelines as a weapon in that battle.
Yeah, absolutely. So, we talked about.
To ask for full. So we're talking about the penalties, but it's not unthinkable. It's clearly foreseeable that the carrier is going to use this to say, if you haven't complied, we get all the money back we paid you.
That's exactly
Which
right.
is exactly what they began to do under the IFPA and ACRA when it was passed back in 1999.
Yep.
So they used it as a complete weapon to ask for full disgorgement. And those cases, there's unfortunately, which I disagree with, but there's already substantial case history in the state of New Jersey getting disgorgement for entirely medically necessary treatment that was rendered, people getting great benefit from it for lack of technical compliance with statutes like this. So a lack of disclosure, a policy of a lack of disclosure is going to result, in my opinion, in lawsuits brought saying we get all of the money back that you have been paid, all of it from our insurance, out of network insurance.
I agree with that completely.
By the way, I should just make one.
Dan, go ahead, introduce yourself.
Yep. Hi, it's Dan Nowak. I'm one of the litigation attorneys here at deal a lot with commercial insurance. I thought I should also mention that in addition to the penalties that Sean was mentioning and Michael was speaking about, there will also be the possibility that you're going to be referred for whatever disciplinary action that they deem appropriate to the appropriate licensing board. They might actually come after your license for violation of any of the provisions of these acts. So again, non-compliance is just not an option.
Yeah. And the extent to which, we don't like delivering news that is unpleasant to people, right? I don't like telling people, but we're confronting the reality. I the book Good to Great, if you've never read it, I couldn't recommend it more highly. Good to Great. It's an objective study of how companies become great and why. The book talks about having incredibly positive, optimistic viewpoints. Maintain your optimism, at the same time confronting the reality, the brutal reality, dealing with it and adapting. So this isn't a negative conversation. It's reality, the brutal reality, confronting it, and then adapting to it. That's what we're talking about.
So, I see some questions about how to deal with some of these issues. Teresa, we're happy to speak after.
No, but let's go ahead. What's the question?
So, some of the payers are failing to provide certain information to their own members. Like, how do we deal with this issue? There's a variety of mechanisms. The question ultimately is, how much are you willing to spend? Because first you have to have the patient on board to address these issues. And there may be possible lawsuits or class actions that can be filed. You can file complaints with Dobie.
But wait, we're going to tell you. Let me jump in. Using complaints with Dobie is an unbelievable weapon. Having and this is okay. That opens up the sales pitch portion. When we're working with our clients and we're handling these litigation processes, we do a lot of this work on contingency. And there's a lot of things that we're happy to put in place as a part of that contingent fee relationship. So there's a lot of things that can happen here for help and assistance that you don't have to pay anything, number one. There's mechanisms for attacking and attempting to get the SPD, the summary plan description, which we're going to address that, Michael, at some level? Yeah, absolutely. So it's coming. And that's going to help you fight these battles and establish you're going to have to fight in battle. And a lot of those things we can help and support you do. Some of these things you can help and do on your own. But you want to create as much leverage over the carriers. They're going to be looking to create leverage over you. We're about to talk about some ways you can create leverage over the carriers, and very appropriately for their violations of the law, which happen every day of the week.
Yeah,
So,
and Teresa, just a further answer to that question is that at the tail end of this, there's certain miscellaneous provisions which we talk about. There's certain requirements placed upon the carriers, which you can then report them to Dobie for failing to meet their requirements. And one of them is providing examples of anticipated out-of-pocket expenses and frequently billed out-of-network services.
So Mike, we've been talking a lot about the disrupting the pattern and realizing what has to change.
Yeah.
We don't have a lot of time. This could easily be an 8-hour day training, right? And we're going to talk about this at the next practice mastery as well, right? Let's start to really speed up and get into some practical mechanisms to get the summary plan description, ways to attack back. Let's go rapidly through some of those things. It's impossible to cover every nuance and disclosure in this 1 hour. Let's give some aggressive elements, some strength back to the providers as we're going through. So blow through quickly, the other pieces of this, and then let's get to that.
Yeah, absolutely. Okay. So, basically other requirements, just very quickly, if your network status changes, you got to provide the covered person that promptly before a procedure is done.
Ready? Okay. There's a whole bunch of disclosure requirements. It's in our slides. Let's skip them. Okay. That's the Michael being a law dork, right? They don't, that's all the stuff that's making people sick. Let's make people not sick anymore.
Absolutely. Okay. So, and I'll get on to the next section. I'll just say that the healthcare professionals, the disclosures are very much the same, except in this case, instead of in writing or having to be posted to the website, there's some of the disclosures are in writing, have to be posted to the website, and some of them can be given verbally.
And by the way, lawyers somehow in this world love telling people all the garbage and the nonsense and the insanity that they're going to deal with. We like providing solutions and optimism and positive progress. So that's all the bad stuff. So let's move forward to some things that can begin to reshape the pattern of behavior so you can continue to be a practice that's out of network and functioning.
Can I interject
Go
something?
ahead, Tom.
Some of you may be aware, because you might have participated, but starting yesterday, we are having a series of conference calls to explain a lot of the things Sean is referring to, steps that need to be taken at the intake, at the consult stage, where a lot of these things that now have to be obtained can be obtained. So Mike, I don't know if you want to mention that, but the HIPAA authorization form, the carrier authorized representative forms will enable you and or us to get the SPDs. Those in turn will enable us to and you to make a more clear determination as to what exactly is happening with that patient's plan and to take the appropriate steps to make sure your recovery is maximized. So they kind of dovetail together nicely.
Yeah, sure. So, I'll hop into that and share some of those details.
Well, let me say this, and we're going to do it a few different times. Respectfully, I think you're crazy if you're not, even if you don't become our client, you don't have to. We're giving all this stuff away for free. We're not putting it behind the you have to become our client door. We're not putting it behind you have to give us your information to get something. We want to give this out. This is outrageous what's happening. We want to help. And yeah, the benefit's going to be that you love us, get to know us, and want to work with us. And that's going to happen with a lot of people. And that's how we built our business for 21 years. Me giving stuff away, me speaking for free, me helping people. And, and a lot of people don't like us for it because we're just bigger, badder. For a lot of people, they're like, oh my God, Callagy, they're, this massive 125 person firm. They're always out there aggressively marketing. You're damn right we are. And we're doing it better than you are. So step back, because here we come. And with all of this, all we want to do is help, support, and do it better than anybody else. You should pick the law firm to work with you who you believe is going to give you the best information, the best representation, and whatever it is. If it's not us, tell us and go with somebody else. If it is us, let us help you. That's our entire sales pitch always, right? Go with the best person. You got somebody better than us and you can find it, work with them. It's going to be very difficult, though, I think, to beat what we're doing. And that's how I feel about it, and that's it. Now, in terms of what we're doing and getting information, email us, right? If you want to be on, added to our email distribution list, you can email me. My email address is scallagy, SCALLAGY @callagylaw.com, SCALLAGY @callagylaw.com. My number is 201-261-1700. That's the office number, 201-261-1700. Just call us. Ask for Michael, Tom, Dan, James, Sean, any of us that are available to help get information. Our next practice, we're not done. I'm just giving you this stuff so you have it now because somebody's jump off. Our next practice mastery event, sorry, the phone call came in. Our next practice mastery event is on June 27th. Is that right?
Yes.
June 27th at 6 p.m., correct?
Yep.
In Edison at the Crown Plaza. Crown Plaza, Edison, June 27th, 6 p.m. We're going to continue discussing these issues. Plus, we're going to be doing additional conference calls. Michael, let's get to practical, helpful information.
Yes, so now we're talking about the self-funded health plans, which is probably going to make up the bulk of the types of claims that you guys are seeing and really processing and going through. And again, we talked a little bit about the summary plan description. That's the key document, okay? And in order to obtain the summary plan description, either the patient has to get it, right, either from their employer or from their plan administrator, or you have to get it. And the best way to do that is to become the personal representative of the patient. There is a document which you can include and have the patient sign when they come in, have them execute the personal representative document and get a HIPAA release form, which you guys are all familiar with. We have models of these documents, which we're happy to provide. But getting those two documents and submitting them in addition to any appeals.
And again, what does this get you, Michael? This gets you the
summary plan description.
And why do you need the summary plan description?
It's the only document that's going to tell you what the reimbursement actually is under these plans, because it's not like your run-of-the-mill insurance policies.
And we have some clients that get none, some clients that get some, and some clients that get all.
Yeah.
Right. And so become a client that gets all.
Yeah.
Right. And we'll talk to you more about how to do that. And we're happy to go, well, why do some of your clients not get all? They're clients that we're not fully integrated with. They give us a case here and there. They don't give us a lot of work, and they haven't, taken us up on our advice and the ability to, influence and help them put these things into practice. It's critical that you do this. And in case you have to jump off, I'm going to jump ahead, and now Michael's going to get frustrated because he likes his slides. He loves his slides. Don't love your slides. Michael loves his slides. Don't love your slides, right? Let's get down to it. I'm busting his chops, and he's going to kill me. Michael's absolutely unbelievable. I'd be nowhere when I would have either of those top 100 jury verdicts without him. That's reality. I bust his chops all the time, and I love him. So this is critical. You need to get a power of attorney also, in case people have to jump off to get to it later. You need to get a power of attorney. It's not good enough to have the power of attorney language you currently have. It has to comply with New Jersey law. It must be notarized. You go, what? How am I going to get notarized? People in your office should become notaries. I'm not kidding. They must. You must get it notarized. In addition, you must unequivocally, unquestionably understand that under New Jersey law, the carrier is going to say that you can't get a power of attorney for a facility. It needs to be in the name of the owner. It needs to be in the name of the facility, and it needs to be in the name of an officer. That's the advice we're giving. Those three things, all three. If it's the name of the facility, they're going to say it's not a valid power of attorney. There's a Third Circuit opinion that I'll let Michael talk about. So go from here. Jump into that for a minute in case people have to get off.
Yeah, sure. So about 3 weeks ago, the Third Circuit has spoken on the issue of anti-assignment clauses. I'm sure everybody on the phone call has had to deal with this issue if you have any self-funded patients. What happens is you have these plans of insurance, and it includes a provision in there called the anti-assignment clause, which basically says it undoes, decades of law, basically saying that patients can assign their benefits to doctors. In comes this plan that now says, no, you can't. You can't assign your benefits to the medical provider. And unfortunately, the courts are upholding
Can I
these
jump
clauses.
in? I'm going to jump in and interrupt Mike. I'm going to do this super fast so we can keep going, run low on time. Listen, anti-assignment clauses said, you have no standing. Get out of here. Take whatever we paid you. You're done. Carriers have been saying whenever we file these commercial insurance litigations that you have no standing, no place to be here. The circuit courts in the West, the Ninth Circuit and others, have upheld these uniformly. There was a massive breakthrough in our Third Circuit opinion, which we're incredibly proud of, that paved the way for medical providers to have standing over the anti-assignment clauses. It did not exist in the United States of America, did not exist. We blew a hole through this argument, and we are proud, excited, and fired up. But you must comply with New Jersey law on how to get a power of attorney. I am not overly dramatizing this. It did not exist. We have hundreds of federal lawsuits on behalf of medical providers that they were attempting to kick out of court, saying you do not have standing because we have an anti-assignment clause. Am I lying, Dan? Every time you go in,
You're
right?
exactly right.
Every time we go into court, we blew a hole through that. Now we need the powers of attorney, but you need a notary. You need to comply with the things we're saying. If you don't, you're out of your mind because you're losing your right to be in court, and you can't lose that right. And you will lose under the anti-assignment clause provisions. That's what's going to happen. That's what the entire country is saying. But the Third Circuit did a beautiful job opening up this opportunity, which we argued, right, vehemently in front of the Third Circuit. And we prevailed on this point, and we're really excited about this opportunity. It is a massive piece of leverage on your behalf.
So, I realize that time is short. We have a whole lot of questions of people asking for workflows through SPDs. Give us a call. We will answer every one of these questions.
We'll do another webinar.
Yeah.
We'll do a webinar next week. Ready? No, this is how we work. We're going to reschedule another webinar. We're going to do one next week. We'll tell you when it is. Send us all your additional questions of things for workflow and how to do this with SPD. But let's keep going through the outline. Get your power of attorney. Get your SPD. We're going to do another webinar on, next Tuesday. Ready? I picked the date. It fits in our schedule. Next Tuesday at same time, same channel. That's it. Done. We'll move everything. We'll do whatever we have to do to make that a reality, to continue answering these questions and making these things happen. We want to give you as much information as possible, as fast as we possibly can. So today is Wednesday. We'll do it next Tuesday. Everybody good with that on our team? Great.
Yep.
Okay, so keep going, though. Get to some of the arbitration, because there was ridiculousness that we heard discussed recently about arbitration and other stuff. Some of the pitfalls of it and other things. Go ahead.
Yeah,
Keep
sure.
going.
So in that context, you have your out-of-network billing requirements. So again, the purpose of this act was to make sure that people who are appearing at hospitals aren't getting surprise bills from out-of-network facilities and things of that nature. And the purpose of this
Not
act
talking about
is-
why, just talking about the facts.
Yeah.
Go.
So this act caps the amount of money that a patient would have to pay directly to the provider for out-of-network services. It instead puts that in the emergency context on the carrier.
Yeah. So, but if you don't get your power of attorney, you're not getting your money. Right? This is the practical. Fair?
Yep.
Okay, go ahead.
So
You agree or no?
Yeah, absolutely. In the self-funded context.
In the self-funded context.
Yeah,
if in the
that's
self-funded context,
which
if
is
you don't
the bigger.
get the power of attorney, it's the bigger
Yes.
thing, you're not getting your money.
Yes.
Because it's capped now for the patient. You got to go to the carrier. Carrier's going to go, oh, you have no standing. Have a nice day. See you later.
Yeah. So absolutely. Yes.
Okay.
So what we're dealing with here-
That is the biggest point of this entire hour. If you don't get that you have to get the power of attorneys now, and you're not going to do that, you're done. You're cooked, you're fried, you're finished.
Right. So
And if we didn't, by the way, if we didn't win that Third Circuit opinion, right, this wouldn't even exist, and we're not having this conversation.
That's 100%.
So the timing of these things was incredible, because that Third Circuit opinion came down only a couple weeks ago, and it saved the ability to do this. So go ahead.
100%. So again, these out-of-network billing requirements apply to emergency or urgent services that are provided by doctors or facilities, and it talks about the capping of the fees.
Talk about arbitration for 2 minutes.
Yep. So I'm just about to get to that. So we talked a little bit about the requirements, and that it's the carrier that you're not going to go after for the out-of-network benefits. It's not the individuals, anything above deductible copay or
Do you have to go to arbitration?
You do not.
Forget the slides. You have to go to arbitration. Let's just start firing questions. You have to go to arbitration.
For emergency services, you do not have to go to
Say
arbitration.
it one more time.
So for emergency services, you do not have to go to
Because
arbitration.
some people might think that this is a wonderful opportunity. We don't know if arbitration is going to be good or not yet. Listen, it would be great for us to tell you, give us all the stuff. We're going to arbitrate it. We don't know if it's going to be good or not for you yet. So we're not telling you to do that yet. Litigation still might be a better alternative. Maybe it will, maybe it won't. We don't know yet, because they haven't hammered out the terms and conditions and the parameters of arbitration. Fair, Michael?
Yes.
So anybody telling you, great, you can go arbitrate, that's great for them, because you'll get work and they'll get into your pocket for your money. We're not saying that yet. We don't know yet which path is going to be better.
Yeah, and I think Sean is picking up on something very clearly stated in the Act, and I think is a super arguable issue, is that this is not a mandatory process, the arbitration. It literally uses the terminology may, which is permissive, right? That's not mandatory. And so although the Act sets up this arbitration process for emergency services, the Act does not say that it is the exclusive remedy, meaning litigation is still available. And the Act does not say that you shall go to arbitration. It says you
so
may.
let me say this, because we're really coming down to it, right? We're not telling you, give us your stuff right from the beginning so we can take your money and get into being a part of the stream of payment for your practice. Some people may be saying that out there. We're not. Keep your money. Do your stuff. Implement all of this for free inside your practice. Keep us out. Keep lawyers out of your pocket for as long as humanly possible in this stuff. Quick commercial, give us all your PIP stuff day one, right, immediately, because that's free, right? That's my 15-second commercial. In terms of this stuff, keep your money in your pocket. Make us a part of your process. Make us a part of your advisors. We're happy to help you for free. Come to Practice Mastery. Get all this information. Keep us out of your pocket as long as you can. When it comes time and you can't, if you want us to do your appeals, we will. We think we do a great job. Yes, yes, yes. But there's a lot of stuff that should be done for you. Great. If you could do it yourself, then do it yourself. Do it yourself. Don't pay a lawyer. Do it yourself. Agree or disagree?
Absolutely.
All right. That's what we're saying. So good. Let's wrap this up because we're out of time, right?
Yeah, we're definitely running short on time.
Yeah.
But so basically, with regard to the arbitration, there's certain principles that you have to apply. It's got to be more than $1,000 difference. There's this back and forth process that exists where they make offers, you make offers.
Listen, let's get the big picture stuff. Let's get out of the details. Anything else they want to cover today? We'll wrap this up. Be at Practice Mastery. Come to the next one. It's free. We don't charge anything, nothing whatsoever. Come there. We're going to give you more great information. We're going to talk about the process of how to communicate about some of these things. We're going to do another webinar next Tuesday. Practice Mastery, again, is at Edison, June 27th, 6 p.m. Call us with any questions. Email us questions so we can give as much practical information, next week. The big points for today are, this is real. There are massive disclosure requirements you have to comply with. You have to figure out how to get the summary plan descriptions, write letters to Dobie. We'll talk about that more on Tuesday, of how to write letters to Dobie when the insurance companies are not complying. You must have notaries in your office. Must. Get them through the program. They don't want to do it. Fire people who don't want your office. I don't want to be a notary. Great. You can't work here. Go get your notary. Pay for it. It's worth it if you're out of network. So we have massive amounts of dollars, huge issues that are at stake here for your practice. And get the power of attorney signed. We'll talk about what needs to be in the power of attorney. 3 different names talked about. It can't just be in the name of the facility. It has to be in the name of the owner and the individual. I did all that without slides, all from my name. We know what we're talking about. What else do you want to say, Michael? Anybody, as we're wrapping this up, because people are going to be dropping off. Okay.
So again, probably the most important things to be mindful. And again, the slides and the white papers we're going to be providing have tons of knowledge on this. I recommend that everybody read it. But the penalties are something that you have to be very mindful of. If you're not in compliance with the Act, for individual professionals, you're talking about $100 a day. In terms of not being in compliance, facilities, $1,000 a day. Referral to the Office of Insurance Fraud Prosecutor.
But worse,
challenges.
complete disgorgement.
Yep.
Criminal liability, complete disgorgement. That's not under the Act. That's under how they're going to use the Act.
That's
right. It's not in there, but that's how they're going to use it. Understand that. Biggest picture is you can do this. You can not only survive, you can still thrive. Out of network is still alive, but there's a lot of challenges. I think that's the bottom line, point. A lot of this can be done for free. Right, we're here to help. Do not just wholesale, make any decision yet about what you do, where you integrate lawyers into your system yet. It's too early. You do need advice, you do need information, and we're here to provide that for everybody for free, whether you're our client or not. Right, that's who we are in this state, and that is what we want our identity. We want to know, Callagy, these guys are awesome. They provide real information, real content. Yeah, of course we want you as our client. Call us, be our client. Wonderful. We'll help you in every single way. But even if you're not, keep getting great information, because we need out of network to be alive and survive in this state, in this country, because it's just good for people and it's good medicine. And we're insurance companies are not in control. Michael, anything else? Tom, anybody?
Yep, I wanted to share just a couple more points.
Go ahead,
I think probably the biggest question that I keep getting is, okay, cool. This is really challenging. I don't want to figure this out. I'm just going in network. That is not a solution that is available. It may or may not be. You may or may not be able to go in network. But in-network has its own challenges as well. Yeah. What's more important now is to...
And by the way, we are happy to help you negotiate that as well. You can do it yourself, but I tell you what, we're expert negotiators, is what we do for a living. If that's the way you want to go, we're happy to help you do it, but it is not our recommendation initially. We do not recommend that you jump and do that initially, unless you're like, listen, I don't really care. I'm in a great situation financially. I want to make a transition in my life, and I don't want to go through all the headache and the hassle. That's your call. But we're not recommending that as the course of action.
Yeah, absolutely. And so,
and by the way, we applaud, at least the positions as we understand them so far, the Doctor-Patient Alliance, correct? Right, that's out there, right? Of fighting to keep out of network alive, right? There's good work. We're getting to know that organization, further. But as of right now, the idea of people standing up and fighting, for doctors to stay out of network and banding together, figure out ways to fight against this, we think is an awesome thing, and we applaud that mission. Right. And, we do. So.
Yep. So, we leave you with, well, going in network's not an option. So what is the option? The answer is evolve, right? Increase communication with your staff and patients. Like, let's make sure they understand the sales process, the education process of the patients. Improve your processes, right? So if you operated under the old regime and think that it's going to cut it, it's not, and you're going to get penalized and you're going to get destroyed. So
And
improve.
real quick, because people could be dropping. We do also want to thank the folks that helped us get this information out there, which was Tom. Anybody know? Let's give appropriate due for who got this information out there that helped us. What organizations?
Actually, the MSNJ.
The MSNJ Medical Society New Jersey.
The Plastic Surgery Society.
Thank you, Plastic Surgery Society.
Hospital Association.
Thank you, Hospital Association.
And to a more limited extent, the Doctor Patient Alliance. Want to thank
Thank
them
you,
as well.
Dr. Patient Alliance. Yeah, and Neuro.
That I'm not sure about.
Okay, we think that the Neurological Society, did as well. We'll have to double check on that. Good. Or Neurosurgeon Society.
So, and definitely much appreciation there. Just additional points is give your patient an experience, not just service, right? And the Callagy Law Practice Mastery, it is completely free. It's open to our medical providers. We do practice enhancement sessions where we help our physicians, our hospital clients, and even non-clients who come into the room and try to help them in terms of educating them in their process.
And we spend about a minute selling, about a minute at the end. The content is outrageously valuable, I promise. And it's been what I've acquired over 20 years of study of personal development, business development. I'm in Tony Robbins' Platinum Coaching Program. I've been doing that. Spent over $500,000 acquiring this knowledge, which blows away. As a Columbia University undergrad, Seton Hall Law School honors graduate, what I learned in law school and undergrad at Columbia pale in comparison, or nothing in comparison to what I've learned in coaching, training from incredible mentors and people teaching me. I am not a guru. I didn't invent all this stuff. I've learned it. I've lived it. I'm applying it. And I consider myself every day to have an absolute open and growth mindset. Watch the TED Talk video on growth mindset versus fixed mindset. It's 15 minutes long. That is what the differentiation is between people who will grow and succeed and adapt in this situation and others who won't. The people that have no ego and are open to ego subjugation, growth, and learning at the highest level and adaptation to move forward and continue their practice, being one that helps people in the state of New Jersey. Anybody else?
Sean,
Tom,
Michael, can we put up the email addresses?
Yeah,
Yeah,
go ahead.
sure. So
Let's put those up. That way people have a chance to write them down.
And we want to thank everybody for taking your valuable time and being on here. If there's things that you think we spent too much time on, please tell us. If you think that you would want to spend more time on, please tell us. It was only an hour. This is a massive amount of content information. And by the way, including influencing you to understand that you can't just do business as usual. We don't like change. Nobody does. My mom was my office manager a long, long time ago. And she worked in my aunt's office before that, who happens to be an attorney. And when she did that, and computers came along, she almost had a heart attack. She's like, I can't learn computers. I don't know anything. All this. And now my mom is, posting videos, doing stuff online, all kinds of crazy stuff in her 70s. And people can change and we can adapt. It's difficult. It's scary. We don't like it. Don't go in a negative prism on this. Deal with the brutal reality of massive change needs to happen. Adapt to it. Beat everybody else. There's opportunity to be ahead of the curve and have your practice be more successful than everybody, because more and more people are going to be dying out, less and less people are going to be out of network, and that gives everybody opportunity. Anybody?
I want to thank everybody who tuned in. I think the questions are amazing. We're going to go over the questions. There is so much material to have here, folks. Please call us. Please ask whatever questions you need. I'm happy to provide the slides. We have about a 15-page analysis that will try to tighten this up as much as humanly possible. As Sean said, there is so much content here. We want to make sure that you guys are all ready to go. You know how to comply. You're not going to get penalized, and you don't feel hopeless like you have to go and network. That is not an option necessarily for you, and there are other ways around this, but you have to evolve.
One more thing, Sean.
Yeah, go ahead, Tom.
Our next event discussing some of these things, particularly the intake and how practically speaking we can deal with all of this, is next Tuesday at 10 o'clock. It's a conference call. If you're interested, shoot us an email with your email address. We will put you on the list. It is a discussion about some of the practical approaches to a lot of this. We will be sending out access codes on Monday.
Yeah. So let's just make that, like, that's our next event. So that's the next one. So it's 10 a.m. next Tuesday. It's already scheduled with other people. You're all invited and welcome to be in it, right? And we'll be providing answers to questions and all of it'll be continuation of today.
Yes.
Right? Is going to be next Tuesday at 10 a.m. I also, would feel remiss if not sharing that this is recorded, right?
Yeah.
We're going to post this and put it up. You're not going to have to do anything to get access to it. We're not putting, like there's a whole concept in marketing and sales that you put information behind the gate so you get everybody's contact information so you can market to people. We're not doing that. It's going to go up. Please share it with people. Please get the information out there. Share with anybody you like, everybody you like, right? We want to be giving information, content, and hope out there. And also the brutal reality of change needs to happen. And that's who we are and what we're doing.
Yep.
Good.
And so just in furtherance of that, there's going to be a YouTube video with this recording posted later, and attached to the comments right there, we will attach both the white paper documents and a copy of these slides and any contact information to reach out to us to answer any of your specific questions.
Yeah, and I want to thank Michael Smikun, my partner. Of course, I was going to hijack some of this today, which I did. Did an incredible job of putting this information together. He's been working tirelessly, leading on the litigation side, our commercial insurance team. I want to thank Dan. I want to thank James, Tom, Tiffany for helping get this together, Henry for helping administer it, and everybody else who participated. Thank you all for being online today. We're going to continue Tuesday at 10 a.m. Please get the Practice Master on June 27th because we're going to have some practical discussions about a lot of things that are happening. We want you to perceive us to be the hub of information education on these points in the state of New Jersey, and we're happy to help. Thanks, everybody, and we'll see you soon.